Hello, my name is John Mayer, and I'm the Executive Director of CALI, the Center for Computer Assisted Legal Instruction. The video you are about to watch is from the annual CALI conference held at the University of Michigan School of Law in Ann Arbor, Michigan on June 4th and 5th, 2026. Most U.S. law schools are members of CALI. CALI publishes over 1,400 interactive tutorials that teach the law to law students. Faculty can also use LessonLink to create formative assessments using CALI lessons. CALI publishes casebooks by paying law faculty to write and review books that can be adopted in many courses in law school. These books are free to download from our website, or print versions can be purchased at near cost. You can download the PDFs or even the Microsoft Word versions of most of our books and add your own commentary before distributing to your students. $300 casebooks are a thing of the past, and adopting one book from CALI saves you more than your entire institutional membership. If you would like to learn more, email me at jmayer@cali.org. I would be happy to visit or zoom into your school to talk about CALI.
Good afternoon, everyone. My name is Jon Garon. I'm the Associate Dean for Technology and Innovation at Nova Southeastern University Shepherd Broad College of Law. Thank you for sticking out this late in the beautiful afternoon and listening to this conversation. The title of the program, AI and IP, What We Should Be Teaching Law Students. So first, just briefly, me, where I come from. So these are the various books that I've had over my career. To give you, I think it's relevant for this talk that I actually started with the Independent Filmmaker's Guide. So I was an entertainment lawyer in California and moved from practice to an adjunct to a visitor, and stayed with legal education. But that client-centered, creator-centric work has informed a lot of what I do, and students and creators share a lot in common, and so that's kind of my approach. I teach tech, I teach IP, I teach constitutional law, I teach contracts. Those are kind of the various areas, and you see that reflected across the works that I've done over my career. So the objectives for the program, because we always want to have learning objectives, is to explore the rapidly evolving intersection of IP law and AI, to look at how these are affecting technology in the creative space in particular, but more generally in the IP space, and then the key legal questions that generates, and then how law school professionals should address the topics in their own work and what core considerations. So those are our learning objectives, but that's not what we're going to do. So I've flipped the program because I don't think there's a lot of IP people at the conference, and quite frankly, I don't think IP is the leading question. I think it's the illustration of the real conversation. And the real conversation, Greg Duell kicked us off with this morning. Heidi's excellent presentation this afternoon. Thank you, Heidi. Right, we've had some great conversations about what we should be doing in the law school. I should also mention that I have been a dean of 2 different law schools and a business school, as well as associate dean, assistant dean, program director. I've had almost every single title in legal education at some point in my career, other than emeritus and other than funded, right? So I'm really hoping for the funded before the emeritus comes, but I'll take them in any order. Right. So the goal for the talk for me is how to make the classroom and the assessments AI resilient or resistant, depending on your attitude towards AI. And then that gives us the core considerations of what we should be thinking about for our students, right? If we want an AI resilient course, what should the course be doing? That's the driven to pedagogy because all of their alternatives are gone analysis that Greg was mentioning, right? We're stuck with having to learn how to actually teach at this point in our careers. And then using that intersectionality to look at IP as the illustration of how you can do this in your own field, and using that to actually teach IP and AI. So that's where we're going to go this morning. All right, so this slide which I give you the reference to it, it's not my own, basically gives us that pedagogical model for how we want to think about moving from a testing, learning, teaching, development, testing cycle for how we think about pedagogy. And again, legal education is last to the table, last to the conversation when it comes to developing pedagogy. Every single skill and knowledge-based discipline is ahead of us in the academy. When I first started teaching back in the early 90s, the model that our school was then focused on was nursing schools. And nursing schools provide an amazingly good skills-based curriculum because it's about deliverables. It's about delivering something to your clients that have life and death consequences, right? Which of course we as lawyers also think we do, and very occasionally that's the case. Nurses do it every hour of the day, and so the techniques that are used in nursing are amazingly sophisticated, as well as the military. And so a lot of my original formation came from looking at how the military trained nurses, because it was the perfect intersection of assessment-based, skills-based training models. Then it all used this, you test first, you then develop your learning. The learning outcomes drive the teaching choices, and the teaching choices turn into individual exercises, and those exercises then become formatively assessed, and we rinse and repeat. Right? It's a very simple model, but it's not one that we use a lot in legal education. In contrast, and I think we've heard this from Greg and others, right? This is not formative assessment. And I think this group, right, this is not the group that I have to sell, but in my law professor's desk reference, I actually did the math for how many minutes a student is actually at risk of being called on if you evenly distribute your minutes for a 60-person 3-credit class. And it is a small number of minutes per semester per student. It is not anything, right? Despite the fear that students have of being called upon, the reality is that they are spending incredibly little amount of time actually being assessed. Again, my background is theater. I do know how to read a room. My colleagues do not know how to read a room. Every time a faculty member says, I do Socratic method so I can tell where the students are, I know that that faculty member really enjoys being themselves. And it has nothing to do with learning, right? So if you want to be learning-centric, you assess your students. You don't watch them and see if they're nodding at your jokes, and if they laugh at your jokes, they must be getting their substantive content, right? It's just that's not how this works. Right. So the biggest challenge that I think generative AI and the move to AI brings to us is that it risks the students no longer developing their critical thinking skills. And that is true for elementary students just as it is true for law students, which means that the students that we're going to be getting every year are going to have fewer critical thinking skills than the year before. Being in South Florida, we saw during COVID, just as an example, that according to the South Florida guidelines, the homeschooled students qualified as being in a COVID competent household so long as there was a laptop in the home. A laptop. There could be 3, 4, 5 children in that home. Both parents could be working full time. So long as that one laptop existed, it was compliant. And what we saw in Florida was the learning preparedness of our students dramatically disappeared as a result of the COVID crisis. And of course, it wasn't evenly distributed. It directly correlated to income level in the household. And so our inner city schools were devastated by COVID, and our best and brightest, most resourced programs, the students had the resources to provide for them. The same thing is playing out in AI distribution, where AI is a crutch for lower income schools, and it is a training tool for better resourced institutions. And this is not the speech that I'm going to give the correlations between income level and race and gender and other attributes, but this is a crowd that I think understands that data pretty well, right? So we have a crisis brewing. I can't overstate the scale of this crisis that is going to hit us, right? And there are very few people who are sounding the alarms in our educational system. There are educators who all understand that this is a looming crisis, but there's very little money being invested. We are defunding and deconstructing the accreditation process right now. And then, of course, on top of it, we're going to hit, right, we have a financial aid crisis that's going to hit now in 29 days, and we have an enrollment crisis that's going to hit law schools in 3 years because the baby bust generation just hit the freshman class, right? So we have all those issues looming with it. So all those things being said, we have an obligation to teach critical thinking at a level that is more important now than ever before. Now, all of us think we're teaching critical thinking. Very few of us actually do it. When I went to law school, right, the Kingsfield kid, your head is full of mush, and I'll make you come out thinking like a lawyer. And I asked, what does thinking like a lawyer look like? And I was told it's thinking like a lawyer. And then I became a first-year law professor. And I asked, what does it mean to teach to think like a lawyer? And it means so that the students think like lawyers. Right? And nowhere did I get a deconstructed, skill-based version of what thinking like a lawyer means. So I spent the last 2 years, as this crisis started to really hit home for me. I've been writing about ChatGPT since 60 days after it came out, right? So this is very personal. And so my model, and it's by no means the only model, really focuses on 4 core components that constitutes critical thinking. First, verification skills, right? And so this is everything from the Stephen Colbert truthiness debate to legal research and writing, understanding the difference between primary and secondary authorities, to what is truth anyway on Facebook or Truth Social, pick your favorite disinformation platform, right? Our students, our society needs to understand what it means to get information and whether the information has veracity in terms of its source and whether or not the information that you get is in fact the information that was provided from the source, right? So there's a number of different levels of what it means to have verification skills. Second, interpretive skills, right? So interpretive skills are focused on not just is the fact true or not, but what is the context for that fact. And I'll spend a little more time on each of these. Third, reasoning. I think many people think thinking like a lawyer is reasoning, and we should go back to teaching a logic for lawyers course. And of course, abductive reasoning, which is what lawyers do, is a component of critical thinking, but it's just one of the 4 components. It's really not, it's not in any way the most important of the 4, although if you don't have basic logic skills, then the others are going to struggle. At one point, I was on a committee that advocated while on that committee, I advocated we return math to the LSAT, and I was not invited back to the committee. But in fact, teaching basic math skills teaches basic logic, which is something that our students actually shy away from. And so basic logic is also missing from legal education today. And then finally, legal ethics, right? What makes our critical thinking different from everybody else's critical thinking is that we frame it from a legal ethics, not a moral ethics, but a legal ethics model that requires that every decision is constrained by the ethical considerations, right? So if you think about Greg's conversation this morning, if you ask an LLM to give you a pleading, It's going to give you every theoretical cause of action that could happen under these facts. If you asked it instead to give you a legally ethical pleading, and you trained it as to what legal ethics require, it would eliminate all of those that would fail a 12b-5 test, that would in fact not be plausible for the court and would be dismissed for failure to state a claim. And so suddenly you go from 19 to 5 causes of action, right? That's a very amoral legal ethics framing example, but there are many more practical ones, right? And so we need to think about this in our formative assessment as well as our summative assessment, and it is nothing that happens in Socratic dialogue, right? This is not what happens. And if you happen to have that one intense conversation with the one student, one of the things about being a former dean, right, I was a lurker. So I'd wander into the back of classrooms, and then when the faculty asked me to stop doing that, I'd wander to the windows and the doors of the back of classrooms, so I was less disruptive. And I would watch both the amount of time the faculty talked versus the student talked, but I'd also watch what happened to the laptops when the faculty got into an interesting Socratic dialogue with one student, and it was about 23 seconds, at which point the laptops lit up. And after about 23 seconds, the students had no longer any tolerance to listen to the one-on-one conversation with that student, and they were gone. And so the faculty member had this lovely, intense discussion with one student, and the other students either went to their favorite sports app or to Amazon. And I learned a lot about shoe shopping watching the back of my classrooms. All right. So just a couple more minutes on, right, how many of you are really interested in the IP side? Because I can spend more time on IP or I can spend more time on pedagogy. Sorry. All right, so we're not going to spend a lot of time on IP, but I will get there because, all right, I'm an IP nerd. I'm a copyright nerd. I love rights of publicity and NIL, so I love them both. All right, so verification skills, right? So verification is the most critical skill that public citizens are missing today, because if you don't know what a newspaper is, if you don't know how to read a newspaper, if you are only getting secondary and tertiary information, then you are not going to be able to make an informed decision because you are only being manipulated, right? It's just as simple as that, right? If you understand the sources of the information you're getting, then you have a chance of becoming an educated voter, an educated citizen, right? So all students, all lawyers need to really learn how to assess the accuracy of the information and the data they're getting, whether it's true, false, or most importantly, somewhere in between, because most information is not entirely true or entirely wrong. Most information has some shade of gray, right? So Oxford Dictionary, the process of establishing the truth or accuracy of something, who created the knowledge, what techniques were used to grab the attention, right? So we all know today that headlines are not written by journalists, and so the headline of a story and the actual story may be vastly different. And that was true even before the modern social media environment, but now clickbait has exacerbated that problem. What is omitted from the information? And we think about this textually, but I actually have an entire law review article talking about visual libel and the manipulation of visual images, both from a real photography and then from a deep fake version, to talk about how much information can be manipulated visually in addition to that which is manipulated textually. And I really think it's important that we teach all of these skills. These are skills that there are elementary and junior high school or middle school programs starting to develop, but again, they're very rare and are very important. Finally, we must always bear in mind that all of our facts are framed by our individual schema and experience. So what is true for me is different than what is going to be true for you based on your learned and lived experience. And we can't forget that piece of this as we're trying to teach these skills. If you make your own schema and your cognitive biases explicit at least you can manage them. If people don't know they even have them, then it's going to be impossible not to manage those biases. This is just one example, a great book that's free and online, put out by the Data Journalism Society. So it is a book for journalists and for people who are interested in journalism. It's a great free resource on the topic. Interpretive skills are the ones that I think need the most explanation. They're the ones that I see the least in the scholarship and literature. So interpretive skills are the meaning, implications, and significance of information, right? Let's assume all the information is factual. Even if it's factual, is it contextual, right? One need only look at the Middle East to understand, right? So we've had war in the region, right, for essentially the entire history of recorded history, right? Since there were texts, there have been examples of the wars in the Middle East, right? If you take all the true information, your worldview about what's happening in the Middle East today, or 100 years ago, or 1,000 years ago, is going to be totally dependent on how you contextualize that information, right? I won't go into the history other than to say that you can take two people who absolutely agree on the facts, who utterly disagree on the reason for those facts, on the understanding of those facts, under what drove the decision makers, because of the context that that information is provided to them and through their lens to you. So the subcomponents of interpretive skills are decoding, right, to understand what is literally being provided, to inferring, right, what is implicit in the statements, right? So there's so much implicit information in every news story and every fact, and so can we pull that implicit information, right? Can we teach students how to understand the context, right? We do it all the time. We understand the context difference between Supreme Court decision, an appellate court decision, a trial decision, magistrates hearing, right? We have experience to understand how each one of those things is different, but our students, those are judicial opinions, right? They are flat. They are exactly the same thing. Students don't understand that when 5 justices agree on something, that is the rule of law. Right? It just is. If 3 judges agree on something, there are 11 other circuits. Right? When a trial court says something, one of my pet peeves in the IP field is you get a district court opinion and people talking about it as, oh, now we have authority. Well, we all know that it's authoritative only to the parties before the judge. Right? It has no meaning outside of them. Now, if it's a really well-respected judge, maybe it's a little bit persuasive. But to the world, because, now I'll use IP, because there have been 2 decisions, interim decisions, on fair use and ingestion of AI, we now have the rule. No, we have 2 examples in a single district for the Northern District of California as to the outcome of that rule, right? And it's time-bound, which if I have time, we'll get to. Right? So those are just examples of how we bring inferential information that is as important as the explicit factual information. Right? Evaluating, are we detecting bias? Are we making assumptions, reliability? Right? You read a scholarly report. Has it been peer assessed? Where did the data come from? Did they, in fact, have a financial stake in the outcome? Those are all questions that we know to ask. Our students don't necessarily know to ask any of those kind of questions when we look at information. How do we synthesize it against multiple sources? How do we bring the pieces together? How do we contextualize it, right? So teaching interpretive skills talk about modeling the interpretation aloud, asking these questions of your students. These are questions that I've never heard or rarely heard in a law school, right? Because what have we done with the casebook? We have stripped out, we have guaranteed them the facts are correct. We strip out all of the context. We tell them this must be true. And so based on that, what is your factual logical analysis? We've actually stripped out most of the critical thinking skills in our tools for teaching critical thinking. So if you just think about that alone, we have broken the model fundamentally, right? Scaffolding with prompts. What's implied? What's missing? What's being assumed? Ask those questions very explicitly, and you start to build a very different Socratic conversation with your students. You'll get a very different chatbot response if you've built these questions into your AI agent than if you ask, what's the holding? How does it tie to the case before? How does it tie to the case after? Change up your media, right? Text has its own biases. Audio has its own biases. Video have their own biases. You need to use different media to explore these contexts. And then, right, practice with ambiguity so that students are in fact being forced to enter the gray, not just what is the edge legal case, but what is the gray factually, right? One of my colleagues pointed out that it's not the theory of the case that drives most litigation. It is what evidence do you have you can get admitted. Most cases turn on what evidence is actually going to go to the decision maker. Having been involved a little bit in copyright cases, some of these big, weird copyright cases, all the magistrate judge does is work to strip out as much fact as possible and get to a legal thing because they're just ugly and massive. You got 60,000 works. Well, what do we do in BARTs? If it's not registered, you don't exist. Right? Tens and thousands of authors who have legal copyright were dismissed from the case because they didn't have a timely registration. They weren't given 3 months to register now that the lawsuit was going on. They were dropped in a week. Because the goal, what is the goal of the court? I remind my students all the time. The goal of a trial court is to clear the docket. That's it. That is the job of the judge, to move on to the next case. Justice, truth, those aren't relevant. Moving on to the next case is the goal. So if we can get rid of facts, we can get rid of law, the docket moves faster. Right? Why do we have mandatory settlements? Does it make any sense? It does if the goal is to move the docket. It doesn't if it's to seek a higher truth, right? But that's how the system is designed. Right? Too much truth? This is a little painful. Sorry.
I just like this is, yeah, no, no, it's great.
All right, right? And we want to engage our students in this conversation, right? So that's interpretive skills. All right, reasoning, that's the thing we think we know and think we're teaching. Right? So analytical thinking, logical evaluation, and decision making, right? I'm not going to spend a lot of time on this other than, how many of you are familiar with abductive logic? So only a couple hands went up. So abductive logic is what lawyers do, because abductive logic is very much the Sherlock Holmes logic. We are fact-bound, we are time-bound, we are utterly constrained. So unlike inductive and deductive logic, it is given all the limitations of what we know, what is more probable than not. Now you can change that to a different level if you're teaching criminal law, but abductive logic is actually built around what does this piece of information tell us, which is very different than the scientific method, because the scientific method allows for us to ask the next question, right? We don't have that luxury necessarily. And so while scientific method is a great way of teaching a lot of what lawyers do, the fact that we are so bound by, right, we know our clients lie, but what can we verify that they tell us and use that to represent them, right? Those are real world questions in the abductive logic world. And then finally, legal ethics, right? Because critical thinking needs to be bound by the, obviously, rules of responsibility, the moral ethics that we have. In most AI conversations, we start focusing immediately on Rule 1.1 competence, on candor to the tribunal, on confidentiality, on billing, right? We skip the first step. The first step in framing legal ethics in the AI competence is the preamble, right? So the lawyer's duty is more than competence, begins with an existential obligation to the public and to the clients, right? What does that mean? It means that the lawyer is representative of clients, an officer of the legal system, public citizen, responsible for the quality of justice. So the first question is this just? Should I pursue this case? Does it promote justice? Because if it doesn't, even if it furthers my client's goal, if it pursues an unjust result, then that's not appropriate, right? We have to, according to the rules, weigh those. Now, in the real world, it's fairly easy to sometimes forget that, but certainly we have to at least do it in law school, because how are our graduates going to ever do it if they aren't deeply wrestling with it at the law school level, right? All professional functions, a lawyer should be diligent, prompt, competent, right? That ties into the easy ones, right? As a member of a learned professional, lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. That's why we're all here. And a lawyer plays a vital role in the preservation of society. And again, my suggestion is that AI is an extinction level event, and if we don't treat that Rule 13 seriously, that what we're going to be left with is going to look even worse than it looks today. All right, so how do we do that? Again, we teach this to our students, make sure they've even seen and read the preamble. I don't think most of my students actually have, because I don't think it's a conversation that we have very often. Anchor the rules to the workflow of AI, to the workflow that they're doing. Create ambiguous assignments where suddenly that question can emerge, and I'll give you some examples of that in a minute. And then, of course, reinforce the verification obligations, the interpretive obligations, and the logic obligations. All right. So how to make the classroom AI resistant. Right. This is one of my favorite slides or favorite images, right? Things I can't teach a dog. Right? Truth is, I can teach my dog math. He just can't learn it. Right? And therein lies the difference. I am a very good teacher. I can teach anything. My dog's not really, he's actually incredibly bright, but math is beyond his skills, right? There are horses who have figured out addition, subtraction, and multiplication, because horses can memorize not the tables, but the body language of us listening to them talking about the tables. Animals are really smart. They can't get copyright, that's a different issue, but they are very smart. Okay, but so we need to flip from a teacher model to a learner model, right? And focus on a lot of low-stakes assessment. Again, you heard earlier presentations, so I'm not going to belabor that low-stakes constant iteration. We need to look for things that the students can't fake with AI, right? So a reflective journal. Could a student fake that with AI? Yes, but how pathetic is that? And I think you can shame students out of having AI write their journal entries for them, right? Just remind them how pathetic that would be, that they don't have enough self-image that they can write their own journal articles, and they won't do that, right? Classroom response systems and polling, handwritten or in-class digital submissions. I was just talking to our friends at ExamSoft down the aisle, because we are expanding our use of ExamSoft to create closed environment so that if I have the laptops open, they can only write in a closed environment. They cannot cut and paste. They cannot go online when they're doing even formative assessments, even doing their journaling at the end of class. A pair share at the end of class is in a closed environment. One of the things that I do, because it's not just AI, I don't like to think of our students as cheaters. I like to think of our students as incredibly tired, efficient human beings, which means if there is a shortcut available, efficiency demands that they use it. And so if I can read either a 20-page case or a 3-page summary of the case, I will read the 3-page summary of the case. If I can pull a 1-paragraph Quimby of the case, as opposed to reading the 3-page example of the case, I will Quimby all day long, right? Because that's efficient. Let's face it, that's what we do. Who are we kidding, right? I go to the syllabus of every Supreme Court decision well before I go to the 250 pages of verbosity, right? Because why wouldn't I? I trust the syllabus from the Supreme Court, don't necessarily trust Quimby. So I have a rule in my class that every time I think a student is reciting to me, they must close their laptop and explain what they just said. And it is great. It outs the student immediately. It highlights that they are cutting and pasting words that they have no knowledge of. Usually generates a laugh and a squirm. And I don't cold call, by the way. I do no cold calling. There are firms. They are assigned in advance. So the student knows from the beginning of the semester what day, what subject, and they're still cutting and pasting and trying to read from the screen, knowing that I will probably call them out for it, and I still get an inordinate number of students who do it, at least the first few weeks, right? But by having that conversation, it changes, right? It sends a signal about the use of technology. And as somebody who uses technology all the time, I'm deep into technology. There's plenty of proper use cases for it. It's not that I'm averse, it's that I spend a lot of time. I give this presentation to my students. I reinforce why it's important that they learn these skills. I operationalize these, and increasingly I am tagging lessons to the particular skill so that the students are getting really explicit instruction in each of the steps, so that when I call them out for circumventing those steps, they understand why that value, what they're giving up in their own experience. I'm a huge fan of handwritten flashcards. There's a lot of cognitive science that demonstrates that handwriting changes the neural mapping of how somebody learns, and flashcards are a really good learning tool anyway, but it is the writing of the flashcards rather than so much the repetition of the flashcards where the learning occurs. And so I give extra credit in every one of my class for students who create good flashcard decks and use them. And I'm up to about a 90% participation rate in them. And then I've every once in a while had a student who needs an ADA accommodation for handwriting. Not for handwriting quality, I'm also inept, but from physical issues. All right. Harnessing interactivity is the key. So I said that I'm teaching a seminar. I teach a seminar every year. And so we have a lot of conversation, and it's on technology, IP and technology. So we have a lot of conversations about the technology and, of course, a lot of examples of the use cases. So live in-class problem solving, a lot of small group work where the students are laptop down, conversing with their colleagues, writing a work product, and then we assess the work product at the end of the session. So they're interactive, highly dynamic during the class. They like to show off their work to their peers in that environment. There's no opportunity to make AI supplant that learning experience. And so the AI just disappears from the table. I talked about the Socratic dialogue with accountability. The think, pair, share, is a great example. So students learn so much from each other, so much more from each other than from us. To reinforce that by having students do a think, pair, share, and then have to defend what their classmates said, So you present what the other person said, you don't present what you said. Again, no opportunity for AI to be involved. It's also a great opportunity to talk about cognitive biases, because when you're interpreting your classmate, all those biases come to the fore, And again, It's not just implicit bias. The Harvard study, of course, that's important, but there are maps of any place between 60 and 250 different discrete cognitive biases, including, right, whatever you learned first is the most important, and whatever you heard last carries the most weight. So just take those two, and you can really play with your students about how they're framing the world, right? And they all know this, because they know who goes first and who goes last changes our perception, right? That's their worldview, so of course it changes everything else. Oral examinations. So in my seminar, students must present their thesis to the class orally. They must then present their outline and basically structure of the paper mid-semester, and they must do a final presentation of their paper. So at least 3 times during the semester, they are orally defending the work that they're doing. If there is a cognitive break between what their written work is and what they can present, it becomes really clear really quickly. I have borrowed from now my dean a podcast assignment so that students will be interviewing a person who writes in the field on which their paper is going to do and has to have a quality conversation with that person, which is recorded and posted to YouTube, so that the student knows that it's not just me, it's not even just their peers, but their potential employers have access to that video and the quality of their work, because the social skills, the interpersonal skills, while not part of critical thinking, are part of durable lawyering skills that I talk about more generally, so reinforce those through the podcast. And so it's all about getting the students to do. And the more students are doing, the less students can rely on the AI to be efficient. And then where it can make them efficient, by all means, train them to be efficient. And so I train students. We do a data hygiene program that I run for all the students, also protecting them privacy and cybersecurity issues. We do a 16-hour technology certification that's voluntary for the students. So it's not like this is saying don't, it's saying do it right. And I think that message, do it right, don't let it interfere with your own skills, goes a long way to build relationship with the students. And the students are reporting to me that that certificate is having a direct impact on their hiring, right? So we've done that for the first time in last January. It's becoming an annual event, and we are seeing that our students are outperforming. The students who have it are outperforming their classmates. Our class is starting to outperform other schools in the market. So it all works nicely. All right. So we've talked about a lot of these things. Process-based assessment, right? So it's not the output, it is the steps that they went through, which again makes it much more resistant or resilient to the AI. In-class proctoring, all my exams are going to close book in-person exams because I want the students to know that if they have blown off learning until the last 2 days, there's going to be a consequence to it. So they know up front that they are investing in themselves, that not only is the bar closed book, but more and more of our colleagues are all moving to this model. For me, it crushes me. I used to all do take-home exams during the formative exams because I wanted them to spend all the time in the world to get it right, and I know how much time they spent on those simple processes, but those can't be evaluated. And so the take-home projects are not evaluated at the same weight anymore as the midterm or midterms, right? And then one of the things that I love doing is I used to give assignments to the students for breakout sessions. I now use AI to personalize those. So I'll create a sheet of 60 discrete questions that need to be answered. Every student is assigned a question. I still put them in groups and let the groups help each other, but each student is assigned one of those, and then that becomes an upload to Canvas. And so students see, right, how it works. Also when it breaks, I identify which LLM I'm using on each assignment so they can hear voice and text of the machines as well. So there's a metacognitive piece to the whole thing where we're talking about how the LLMs operate, whether or not I'm teaching them explicitly. In common law, I spend very little time teaching the LLM in my upper division classes. It's much more appropriate to spend time working on those. There's just no room in common law to distract with that conversation going on. And the students feel like it's a distraction, and so then they'll resist it. And then you create a new cognitive bias, which is I don't like AI because I learned it in a stupid place at a stupid time, and that creates its own long-term baggage. You have to think about those metacognitive aspects of it. All right, I want to get to there's some more slides on improving reasoning, critical thinking. I want to get to AI. So first, this is Wallace and Gromit. I'm sure you're familiar with Wallace and Gromit. Why do I have a picture of Wallace and Gromit in here? Because for another presentation, I told it to give me a demo, a slide of my speech using the style of Wallace and Gromit. And so what did Gemini do? It ripped off Wallace and Gromit, right? And so I was giving a copyright presentation where it utterly ripped off two characters, which offended me deeply, but created a great teaching moment, right? So there's Gromit, there's Wallace, right? Obviously teaching patent law. All right. So I don't have the time to explain IP. If you're interested, there are books. So instead, I want to highlight, so just very briefly, I never teach AI at every level of depth without talking about the risks associated. So you heard Greg talking about environmental harms. Now we're having the NIMBY issue and huge data center crises and the like. So this particular talk, 5 of them are highlighted in the conversation. We've actually touched on most of these, at least briefly. But so I always keep this slide in and just remind people that there's a societal consequence to AI. It's not all wine and roses. There is good as well as bad. Now moving to IP, it democratizes the creation of content. And that could be a really good thing, right? We think about in fine art becoming visual art, how good it was that the academies were deconstructed by the naturalists, surrealists, and other artists in the 19th century. So maybe it is time to deconstruct Hollywood, to deconstruct the music studios, and to make art available for creation by the masses, right? There's a lot of good in that. And you hear a slight cynical tone to my voice, but there's a lot of good to deconstruct the monopoly marketplace that we have in the creation, right? But I started my career in Hollywood. I started my career representing independent artists, right? Very little studio work. Most of my time was with independent artists. What is the number one concern my artists have? Eating. Right? Insurance is a secondary and tertiary goal. Just not having to work full-time as a waiter was really the primary goal for most of my artists early on in my career, right? So if we take away the economic tools for creativity, we destroy a class of creators. More importantly, most creators are not Taylor Swift. They don't show up on a TV show and go from a TV show to a multi-billion-dollar career. They start out in a club, in a studio, shooting a short video, teaching, and eventually build their craft over years or decades. And if we don't pay for that work anymore, we will not have the next generation of professional artists. Right? This is why in the creative area, it is an absolutely existential threat to creativity. This illustration is only loosely related to it. Die or Dry is one of my favorite cartoons, right? But we have to find a way to pay for our artists or the entire system fails. So it's an existential threat. And I'll make the slides available to anyone who's interested as well, by the way. So I'll probably end here and try and leave a couple minutes for questions. IP ethics. This is the difference between an adjunct teaching your IP courses and one of us teaching your IP courses, if you do it really well. All IP rules are ethical policy choices. Every single rule that goes into copyright, patent law, trademark, trade secret, rights of publicity are value judgments the society has put on innovation, invention, ownership, distribution. Right? So what is this example? This example highlights that the steam engine was invented in 400 BC. Society, Western society, has known for 3,000 years, if I'm doing my math right, that steam could power industry. But what happened? Well, there was no patent system, so it was a trade secret. So from 400 to 200, 400 BC to 200 BC, it was a secret used in stagecraft to move special effects across the stage using heated up props. So birds could use steam to fly across the stage, and there was other techniques, right? It became known in about 200 BC, not in the most efficient version of it, but this could have led to the steam locomotive by the turn of the millennium, had there been any economic system to reward it. But what was the economic system? Slavery, right? Value judgments. If you have slavery, you really don't need steam. And so we didn't reward, there was no patent program, there was no reward for invention, and there was a huge economic interest in the Roman Empire in collecting human resources and repurposing human resources, which lasted until 1863, right? Value judgments. Every rule is, in fact, a value judgment. And using these examples and other examples really starts to get students to think about that duty of professional responsibility, that obligation to society, that obligation to think much more deeply. So here are some examples, one example for each of the 5 IP areas. In copyright, fair use versus enforcement, this is a true case for me. I did do some work early on in my career. Disney was a client, and so Disney, this was back in the late 80s, early 90s, Disney's policy was sue them all. It was a very simple policy, very straightforward, right? Disney was also a huge consumer of fair use. You think about the entire category of public domain works that were Walt Disney's creations. And so talking to students about having a client who is being sued for violating, sued to enforce saying something's not fair use while at the same time being sued, claiming fair use, creates that great moral ambiguity to teach what fair use actually is. Right? It's a great way to get into the depth of that discussion. Patents, workaround versus enforcement. So first of all, we have a crisis, right? As you know, right? Here's a little teaching moment. AI systems, LLMs, are not humans. To be an author of a copyrighted work or an inventor of a patented work, you must be a human. My favorite case actually involves an elephant. Most people know the monkey instead, but there are plenty of examples. There's also some great cases of people who think they were talking to God, and if you file saying a deity wrote my book, you can't get a copyright. If you say I interpreted it, and here's the translation of the deity, you can get a copyright. Right? So humans have to be authors, and they have been since the foundation. Right? Patents, it's even more difficult. Not only do humans have to be the authors, but you have to not work around the work. So Google, back in the day, before Google started making money on owning patented stuff, had the philosophy that it was losing money because of patents. It didn't like paying patent rights. And so it was publishing anything it could find to destroy the patentability of future inventions. Well, with AI, you can just publish an infinite number of possible solutions to stuff and create a prior art umbrella that destroys the ability for later inventors who actually have proved the usefulness, because that's not the inventive step, right? So that tells me the patent law system's going to have to change. Proving usefulness is probably going to become more important than coming up with the idea if the ideas are free. But until then, great example, if you have a company that's destroying patents and trying to patent its system for destroying patents, you can teach those ethical values to your students. A lot of cognition, a lot of the meta thinking that goes into it. Trade secrets, secrecy versus mobility. This is just a simple ethical issue. Constant issue. There are companies that are applying, and I wrote this before the government decided it was going to send out universal NDAs to all governmental employees. So it's only gotten worse, right? But really, paper boys have NDAs because your competitor is going to know the bicycle route you take? That's a real case, right? Do you as a lawyer bring that case? I would say you should be sanctioned if you bring that case against a 16-year-old on her bicycle for violating the corporate NDA. Fine, you can bring it in court, but you're going to sue the bar, right? And that's a conversation we can have with our students, right? Rights of publicity and likeness, obviously this has become a huge issue. So we're talking about deep fakes, we're talking about non-consensual pornography, we're talking about where the limits are on representational rights for individuals. And then we ask the question, and there's a chapter that I actually wrote in the feminist theory book on why it took so long for rights of publicity to be recognized, and the fact that most of the early cases involved women. And most of the judges didn't care, right? And so there's this huge bias in rights of publicity cases because the rights of publicity would have protected women's rights much more actively than men's rights. Why did it become popular? Why did we flip the script on rights of publicity? Because college athletes advocated for their protection. Ed O'Bannon, Terry Hart, and other now professional athletes argued that their colleges shouldn't be making millions or billions of dollars off of them. And suddenly the moral value of rights of publicity flipped. So again, great opportunity to teach the doctrine, but also to show the underlying value judgments that society makes in teaching those rights and teaching the critical thinking skills, the ethical issues that go into the IP considerations, and driving home the 4 critical thinking skills that are essential to understand at a deep level what IP is actually all about. Right. Left 5 minutes for questions. I will stop there. Questions? Too much? All right. Please. I think that's a great question, and I think it does relate actually to the materials, right? So you can use AI. Cali is very open to using AI. I'm a Cali fellow this year, and I've leaned very heavily into Claude to develop the lessons that I'll be putting out this fall. And it's con law, there's more resources online than anything else, so it's very simple to have it. Every link is tied into Justia, so the students have it open source. Great tool, right? So what that tells me is, right now, what is stopping the old world is publisher monopoly. The publishers enforce their copyright, so West, CAP, Aspen, for us, right, all insist that you sign some version of a statement that no AI was used in the creation of this work, right? And so that monopoly will continue for a number of months. At which point, Cali and others are going to start creating Creative Commons works to compete with those, where a human editor is going to be paid vastly less than your copyright royalty to site check and make sure that those works are good and present those for free. And so I'm fearful that the three companies I just named will all go under. Right? And that creates a huge disservice to us. So we're going to continue to invest in those three companies because we need them, because AI is not going to create new pedagogical materials for us, even though it's creating new secondary sources. So we're in this weird economic loop. What is going to happen is, unfortunately, right, I have spent my career in, regional schools. Right? I will not buy into the US news hierarchy entirely, right? But I've been in regional schools. And we already know that your time and attention on, right, if you want a Wikipedia page, if you want to get a lot of attention from Google, you need to be at an elite institution, that it values being at Harvard or Yale very differently, right? 2 years at Harvard are worth more than 40 years at a regional institution. By the next round of this conversation, we are going to be using trademark rather than copyright. And so all the secondary sources are going to be restricted to elite authors because their CVs are going to justify the work's existence. And for 2/3 of us in the academy, we are SOL. And that's going to be a really sad thing. We are going to go the same way as my creative clients, unless we come up with a fundamentally different model, and I don't see anyone talking about that model. Any other questions? I see I'm at time. All right, thank you very much.